Hello students, welcome to the EPG Pathshala. I am Dr. Rashmi Sharma, Head of the Department OB and HR, Lal Bahadur Shastri Institute of Management, Delhi. Today we will learn the module Employee Rights and Managing Discipline. This module is from the paper Contemporary Issues in HRM and Future Trends. We will be introducing the concept of discipline and employee rights and also learn how to manage discipline. After completing this module, the students would be able to understand the rights of an employee and learn how to manage discipline in the organization. When an employee joins an organization, there are certain expectations that the employee and the employer has. For an employee, certain expectations are nothing but rights. The employer has different expectations from you as an employee. Your new colleagues will expect you to approach the job with an open mind so that you can quickly learn what you need to do it well. If you really want to make an excellent impression and exceed your employer's basic expectations, you must try to cultivate a cheerful and a flexible attitude. Things are often more complicated in reality than they appear on the paper. So, the company's organizational chart might not be sufficient to describe everything that actually needs to be done. If you display resentment when asked to do something outside your normal responsibilities, your boss might be disappointed. The relationship between you and your employer is likely to run into trouble if either one of you feel that expectations are not being consistently met. Some of these situations are unambiguous. For example, if you do not get your salary when you are supposed to, your employer is clearly not meeting a legitimate expectation. If you leave the office an hour early every day, you are not meeting the expectations of your employer. Other expectations might not be reasonable as well. If your employer expects loyalty from employees but does not extend the same loyalty to them, this may not be fair. If you expect to be promoted after you've been working there for a year, this may not be reasonable if you haven't executed your task or excelled as an employee in that organization's department. Whenever you are dealing with some kind of expectations, it's always important to assess them objectively to decide whether they are reasonable or not. After having understood what are employee rights, let us understand the concept what exactly are the rights of employees and how it can be asked for. An employer must provide a written employment agreement even before when you start your work. A majority of private employment in India is bound by the terms that are mentioned in the appointment letter. The letter forms the basis of the contract between the employee and the employer and is enforceable both ways under the Indian Contract Act of 1872. It is advisable to carefully read the entire employment letter before signing on the dotted line, as this saves trouble later. Protection from sexual harassment at the workplace is another right that can be exercised by the employee. It is the responsibility of the employer to ensure that his or her employees, especially the female employees, are protected while at work. All the incidents of sexual harassment, regardless of how big or small they are or who is involved, requires the employers or the managers to respond quickly and appropriately. Just because someone does not object to inappropriate behavior in the workplace does not mean that they are consenting to the behavior. Leave is the right of all employees. Generally, an employee is given the following leaves during the course of his or her employment. Casual leave is provided to an employee to take care of urgent or unseen matters like a family emergency or emergency. Sick leave is provided when an employee gets sick. Privileged or earned leave is referred to a long leave that is taken or planned in advance. Other leaves apart from the above mentioned leaves, there are some paid, unpaid or half paid leaves which are provided at the discretion of the company. The Maternity Benefits Act in 1961 was enacted with respect to the employment of pregnant women in establishments. Earlier, the law mandated that a female worker was entitled to a maximum of 12 weeks, that is 84 days of maternity leave. Of these 12 weeks, 6 weeks leaves are for postnatal leave. Employees are also entitled to 1 additional month of paid leave in case of complications that are arising due to pregnancy, delivery, premature birth, miscarriage, medical termination or a tuberculotomy operation, 2 weeks in this case. With the new amendments that were made to the Maternity Benefits Act in 1961, the paid maternity leave has been extended from 12 weeks to 26 weeks for women working in the private sector. No employer can employ a woman in the 6 weeks following the date of her delivery or miscarriage. It is also illegal to discharge or dismiss her on account of such an absence. Employees cannot be discharged or dismissed while on maternity leave, nor can there be any disadvantageous change to their conditions of employment. This can be overruled in case of gross misconduct or if employees take up work for another establishment during their leaves. It is important to note, however, that the pregnant employees who are discharged or dismissed may still claim maternity benefit from their employer. We all have heard of the term gratuity. Gratuity is nothing but a statutory right of an employee and cannot be denied to them on the grounds that they are being given provident fund or pension benefits. Gratuity is a statutory benefit that is paid to an employee who has rendered a continuous service for at least 5 years. It is a lump sum amount paid to an employee on the basis of the duration of his total service, that is more than 5 years. The benefit gratuity is payable to an employee on the cessation of employment either by resignation, death, retirement or termination, by taking the last drawn salary as the basis for the calculation. Gratuity is an important form of social security and is looked at as a gesture of gratitude by the employer to the employees, paid for in monetary terms for the services that were rendered by them to the organization. It is a defined benefit plan and is one of the many retirement benefits that are offered by the employer to the employee upon leaving his job. Gratuity payable is a liability of the employer which tends to increase with an increase in salary and the tenure of an employee's employment. Now let us understand what exactly is a provident fund is. Employees Provident Fund, that is EPF, is a retirement benefit scheme that's available to all the salaried employees. It is managed by the Employee Provident Fund Organization of India, and any company with over 20 employees is required by law to register with the EPFO, that is Employee Provident Fund Organization. As per the law, both the employer and the employee have to contribute 12% of their basic salary to the Provident Fund. If any employer is deducting the whole PF contribution from only the employee's salary, then it is against the Act, and this employee can apply against the same in the PF Appellate Tribunal. You may think that is it necessary to contribute to Provident Fund? If you earn more than rupees 6,500 a month, you can always opt out of contributing towards EPF. However, you need to opt out of it at the start of your career. If you have been a part of EPF even once, then you are not allowed to stop contributing. If you have to manage discipline in your organizations, then there are few things that need to be followed. It's important to establish the rules and goals. The rules have to be clear and logical, along with the atmosphere of trust between the management and employees or labor, because ultimately it will minimize the disciplinary confrontation with the employees. Often it's the manner in which these rules are established and enforced that makes the difference between a smooth running operation and a company that is plagued by employee related disruptions. First, any rules that are established by the company should be reasonable, and workers should be consulted before the rules are adopted. The rules and consequences for breaking them should be known and well understood by all the workers. They should be impartially enforced, with any punitive actions understood by the employees beforehand. You should be flexible in the enforcement of certain rules, taking into account the circumstances whenever applicable. The communication channel should also remain open so that the employees feel free to question any rule that they feel are unreasonable. If a circumstance arises if an employee warrants punishment, then you should develop an employee warning system which should be implemented in a predictable and logical sequence and should be easily adaptable to varying circumstances. For example, you might devise a system by which the employee is generally reminded of the company policy on a certain issue the first time, such as a warning is warranted. The second time, a sterner warning is given, often in the form of a written reprimand which outlines the past performance and the prior warnings that are given. A probationary and a final warning can also be issued in the third time, with a thorough accounting of employee performance and a clear understanding that violating the probation will result in dismissal. All such warnings must be done in private so as not to embarrass the employee, with counseling that should be offered on improving the performance. The warning should also be recorded in the employee's personnel file. The weight behind them, or they won't be taken seriously if a probationary warning is given. There should be a systematic follow-up through the next time a serious disciplinary action is needed. Probationary period should have an established time limit. The probationary warning should make clear that what you expect in the way of performance improvement and over what time frame. It's important to document the poor performance. You should get an agreement on these goals and deadlines in writing and have the employee sign the form so that you have completed the documentation on file. This written process forces you to analyze exactly what poor performance means to you. Every 6 months, reviews or efficiency reports should be conducted for each employee after an initial probationary period. Reviews should be more frequent during the probationary period, perhaps monthly. Write a dated memo for the person's file whenever applicable or whenever a problem arises between the two reviews. Dispute amongst the employees, missed assignments and the likes that should be documented in writing. This not only helps you to do a better evaluation but also serves as evidence if you really need to produce the later. If your employee doesn't make a comeback in performance after being put on notice, you must replace that person. The best way to approach this situation is quickly, without procrastinating. Use compassion and sensitivity while dealing with that risk. Avoid lecturing and, above all, do not resort to the shouting match. Limit yourself to the facts that are supported by the written documentation. When you have to terminate the job in haste or on the basis of fuzzy evidence, be aware of the fact that it can cause more problems in the long run than the ones you think you are solving. In these cases, it's better to try to turn the employee around than go through the painful hiring or firing process unless the person has committed acts that are clear grounds for immediate termination, such as impropriety, gross incompetence or theft. Termination always comes with a lot of emotional baggage. Shock, anger and surprise are common reactions on getting fired, even amongst the employees who knew that their performance was slipping and have been warned in advance. The important thing to remember in dealing with such reactions is that a person who wasn't right for you as an organization cannot be right for someone else. There are several ways you can make an exit easier for the departing employee. The timely payment of all the money that was due to the person is very important and will also keep you as an employer from running afoul of the applicable state laws covering employment. Some companies let the departing key employee use the office and secretarial help for free or at a modest cost while he or she looks for another employment. And that activity, as we already know, is an outplacement activity. Allowing the terminated person to submit a letter of resignation is another means of removing the stigma of being fired and makes it easier to find the other work. A letter of recommendation that does not exaggerate the abilities or might cover any problem may be appropriate, as may pointing the person in the direction of job opportunities that you may know about. In some cases, companies have found it worthwhile to pay for the services of an outplacement firm that helps the key individuals pick up the pieces and find another job. This is done, of course, out of an enlightened self-interest on the part of companies who can easily be exposed to litigation by a disgruntled ex-executive or a professional. In this module, we have learned that when an employee joins an organization, there are certain expectations that both that employee would have and the employer would have, even their team members would have. For an employee, certain expectations are nothing but rights. For example, an employee has the right to expect things from the employers, which includes timely and accurate payment of wages, adequate training, safe working condition, and full explanation of the company's policy, especially of the job responsibility, and fair and constructive feedback from the supervisor. Thank you.